Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane and what you saying, yo. Silly with my 9 milli with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, every while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug, nigga named Moody, yo. He moody, yo. Like a nigga that'll slap me with the toolie, yo. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga shorty, she a little cutie, yo. The way you shake it, nigga, you wanna get all in the booty, yo. With no lanes and what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the go ball.
Yo, 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 yo. Diva's in the building. Welcome back again, guys. Good afternoon. Once again, almost evening for some. So, I did a poll the other day, and I asked if you guys wanted to me to break down the letter that Bone Sheen had replied to the government. Okay, and I think we should break that down so we can get a better, clear understanding. Right? I'm not a lawyer. Let's put that disclaimer out there right now. I am not a lawyer. I am trying to learn law and interpret it as best as I can and give you guys the best interpretation of what I understand. And we can figure it out together, right? That's what we're here for, right? We want to learn, we stay focused. That's what it is. I'm not dealing with none of the shenanigans that's going on. The shit that happened. We're leaving it in the past. And for me, that's what it is. So I got better things to do. So let me say hello to everyone. Good afternoon, Mountain of Inspiration. Hello, and thank you for the thumbs up, sir. Flawless, hi, baby. Noni, I love you, Noni. By the way, this weekend I will be having a kind of like a baby shower. Not really so much like a baby shower, but I'm going to announce a registry for Noonie. She is expecting, and her due date is in the end of May, but she's feeling like she's getting ready to go really soon. So I'm hoping that this weekend she doesn't have the baby yet, and I'll give out the registry. And I want to be able to promote some businesses as well. Um, and we're going to have I Am Queen Newton as well as Miss Vanetta. I would love to have my sister, um, Miss Frugal. Yes, yes, Miss Karen J. come up on here. Anyone who has a business, I would like for you guys to join the panel either this Friday or Saturday. I will do it. I will set it up either for Friday or Saturday. And if you ladies or gentlemen who own businesses, please, I want you to join the panel and promote your business. Okay? So we're gonna have a baby shower slash promotional announcement day. Something positive. Let's get away from all this negative because everything with R. Kelly is demonic, negative, all of it. And that just goes to show you, you know, he's always had a cloud over him. And people who go under his umbrella get struck by lightning too. So that's all. So let me continue saying hello. Oh, you ready? You ready? You ready? You ready? Inspiration. Cat talk. Hi, lady mama. How are you feeling, baby? I hope everything is wonderful with you. And matter of fact, to all my loves that are sitting in the bushes, you know, I'm sending my love to you as well. And I hope you guys are having a great day as well. And maybe hopefully one day you guys can jump out of the bushes. I really want you guys to jump out of the bushes. I don't want you guys to be afraid of chat or giving your opinion. You know, I really would love for you guys to come out one day. And for those who are in the bushes, who are my haters, hi haters. What's up? What's happening? Love to y'all too. You know, haters deserve love too. So, lovelies, fair. What's up, papito? I'm so glad I know you're a boy now. I swear to God. We need to change your avatar and put a boy face or something up in there. Because there's not too many boys up on this side. Hey, Bev Davis. What's up, mommy? Miss me, Miss Mo. Short Tay. What's that? What's that? Karen Johnson. Hi, lady. Pita, pita. Yo, yesterday you was saying mad shit, and I was catching everything you said, baby. I was catching everything you said, mommy. And I agreed with everything you said. Okay? What's up, Peter? Too strong warrior. A warrior. What's up, baby? Danny. Hi, Danny. Just V. My freaka leak on the other side of the world. What's up, lady? Hey, Matisse. How are you, mama? I'm just saying hello. Everybody's saying hello, so I'm saying hello as well before I get into the deep shit and we get lost. Hey, K-Love. What's up, mama? Yes, yes. I did get that, Miss Me, Miss Mo. We are going to talk about Mr. Lawrence Gray. Yes, we are. I have his indictment. Yes, we are. We are. I'm definitely going to try to schedule that maybe, maybe Thursday or, let's see, sometime during the week. All right. And we also will continue with the last part of Larry Nassar. And we're going to start with, I'm almost done with the book as well, that Sloan Woods 9. I'm almost done with reading that book too. Um, and then I want to get back into Lizette's book. All right. I want to get back into Lizette's book too, guys. You know, hey, Ton Bella, what's up, mama? T Bam, what's up, baby? The government did not the government sealed the letter. They put it in seal, they put it under seal. There's a reason why. It might be due to whatever they might have said that they do not want the public to know. I'm gonna straighten all that out because we know that Sly Fox ain't all. We know she ain't got it all up there. We know that. We know that Sly Fox does not have it all up there. Okay, okay. I'm not a lawyer. Like I said, we're gonna learn this shit together. Okay, simple as that. We over here know how to comprehend, Google, you know, learn and understand, comprehend over here. Okay, like I said, we on a GED level, but people are all over. Kayla, my chuleta, what's up, my chuleta? Okay, all right, everybody got it out the way now. Everybody got it out the way. Everybody say good morning, good afternoon, good evening. We're all from different parts of the world, so we're in all types of time zones right now. Okay, now, Miss Bonjean on April 9th, 2022, she submitted a letter, okay? It's not a motion, it's a letter, okay? Okay. When it comes to letters, they do not have to always put it in as a docket number, okay? These things don't always have to be attached as a docket number. It's just the letter that was submitted, okay? So let's clear that up, all right? Because as you can see, there is no docket number. If you go to oh, if you go to the paster, right? The CMECF, okay? When we go to the electronic filing, we go through it, and here, wait, let me- like, there's an order that went in here, right, on February 18th, and it was the order put in by Judge Donnelly, okay, and it had to do with the response to Bonjean's um, file to supplement to the Rule 33 motion, okay, as well as um, the memorandum in support to uh, his acquittal. So when she did that, right, because that's how it all started, correct? It started with the motion 269. Okay, so we're gonna get into all of that in a moment. All right. So like I said, when she puts this in, it's just a letter, okay, and there's no document number attached to the letter. Not always, okay. It's not necessary. All right. She said in here, dear Judge Donald, dear Judge Donald, please accept this short reply letter, okay, a reply letter to the government's letter dated April 7th, 2022. Okay. Now the government put in a letter. She said April 7th, 2022. Right? All right. April 7th, 2022. Now, that is the day that the government submitted their response in opposition to the document 285, which was the motion for reconsideration on motion to continue sentencing. Okay, and Bonjean put in that letter on April 5th. So they responded to her reconsideration motion to continue sentencing, right? So that's docket number 286 because it's a motion, okay? Now, before that, Judge Donnelly had put in an order. Okay, Bonjean had put in her motion, right? Okay, hold on. Let me do this first, and then I'll get to the other. Just so I can clear up the mess, okay? Hold on. I'm gonna clear up the mess. I'm gonna clear it up. I'm gonna clear it up. I'm breaking up. I'm breaking up that bad. Bad. You guys hear me? Microphone check one, two, one, two. Oh, guys, sorry. Do you guys hear me? You guys hear me now? Yeah, now I'm paying attention to the chat, guys. I'm back. I'm off the screen. I'm not behind the scene. Do you guys hear me now? Let me know. Give me a thumbs up if y'all hear me. All right, do you guys hear me now? Give me a thumbs up if I sound better now. 20%. I'm still not 100%. Really? Goodness gracious. Okay, how about now, guys? Still breaking up. Oh boy. You guys hear me now? You guys hear me now? How do I sound now, guys? Trying to find a good microphone cheap, but good, like something that'll fit on my little desk. You guys hear me? Still low? Am I still low, guys? Very low? Oh, oh. How about now? How about now? Hello? Can you guys hear me now? Do I sound better? Am I choppy? What's going on? I'm hoping I sound better. Sorry if there's any noise in the background as far as like TV sound, but my husband's watching TV. Can you guys hear me? Yes, amen. Do I sound okay though? Okay, I sound better now. Good. Thank God, Jesus. I am so sorry, y'all. I am so sorry. I will get it together eventually, with sound and, like I said, having my own space one day. In the meantime, please excuse me, guys. All right, that sounds good. Okay. Let's try this again. Damn it. A whole half an hour wasted. Okay. Mm, 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 mm. All right. I'm gonna go over this letter first, and then I'm gonna go over the whole fiasco of the motions, all right, that were put in and timelines and all of that. So guys, I apologize. I'm off the screen right now. I'm not working on my phone, so I can't see what y'all saying. Matter of fact, let me situate my phone. Okay. As that is the only other way that I can watch you guys. Okay. 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 All right. Live chat. Okay, guys. So I sound good. Good. Awesome. Thank you. Hey, Miss April. How are you, honey? All right. So, as I said, the defense lawyer for R. Kelly, Jennifer Bonjean, submitted a letter to the courts. And in the letter, she says, "Dear Judge Donnelly, please accept this short reply letter to the government's letter dated April 7th, 2022. Defendant does not contend that a Miranda violation will occur if his sentencing hearing proceeds before resolution of the Northern District, Illinois case. Rather, defendant argues that to provide fulsome mitigation evidence, he will have to waive his Fifth Amendment right. Thank you, Mama. His Fifth Amendment right, and that carries serious risk. Defendant maintains that it is fundamentally unfair that he should have to make that choice when so much is at stake. Second, defendant appreciates that all defendants who have been convicted of an offense run the risk of self-incrimination when they participate in the sentencing process. But this case is unique and distinguishable from De La Paz. First, defendant is not seeking a continuance of his sentencing hearing merely so he can exercise his right of allocution, although his right of allocation, I'm sorry. Yeah, allocution, and then it says allocation, is unquestionably compromised if his sentencing proceeds before the Northern District Illinois case. Rather, defendant seeks a continuance so he can speak more freely to a mitigation expert about his own history and develop evidence that may shed light on the offense conduct for which he has been convicted. Second, because the offense conduct in this case spans decades and overlaps with the charged conduct in the Northern District Illinois case, the risk of self-incrimination is particularly high. Again, sentencing in this case will involve discussion of defendant's life and character, not merely isolated events. For that reason, this court should have a full understanding of who Robert Kelly is. The one-dimensional portrait the government has painted does not tell the complete story, because the government has labeled every person in proximity to defendant as members of his inner circle and enterprise. Many individuals who could and want to provide mitigation information about the defendant are fearful of doing so. Thus, defendant is his best source of mitigation, but he feels limited in his ability to do so with the Northern District of Illinois charges pending. The defendant understands that his sentencing hearing cannot be postponed indefinitely, nor does he ask that it be continued until resolution of every state court criminal and civil matter he faces. He merely asks that, in light of the serious federal prosecution that is scheduled to commence on August 1st, this court grant a slightly longer adjournment. Granting this adjournment would appropriately balance defendant's guarantee of a fair sentencing hearing with the interest of his accusers, who will get their opportunity to be heard publicly. Should the Northern District Illinois case get postponed, the government would be free to object to any further adjournments, which defendant accepts would likely be sustained. Okay, let me get something to drink. Ah. Okay. So, and she says, respectfully submitted, Bonjean. And of course, everybody got a copy. Now, in this letter, she says that R. Kelly does not contend that a Miranda violation will occur. So I'm a little confused by that. You know what I mean? Because so Hey, James. Hey, Tasha. Hey, Take. Hi, I am Queen. What's up, Missy? Hey, Spiritual Gangster. Wings. SK. What's up, ladies? Yeah, so I'm trying to figure this out, y'all. So, definition of Miranda, right? It's relating to or being the legal rights of an arrested person to have an attorney and to remain silent so as to avoid self-incrimination. So your Miranda rights is the legal rights of an arrested person to have an attorney and to refuse to answer questions. Right? So, as the right to remain silent, to have an attorney present, and to have an attorney appointed if indigent, of which an arresting officer must advise the person being arrested. Reading of the Miranda rights usually includes a warning that anything said could be used as evidence. No statements made by an arrested person or evidence obtained therefrom may be introduced at trial unless the person was advised of or validly waived these rights. A fresh reading of the Miranda rights may be required by the passage of time after the initial reading, as for example, if a previously silent person begins to speak or police interrogate a person more than once. Okay, doesn't say any more about it. Oh, you really? Let me see here. So basically, it's his right to remain silent. Anything you say can and will be used against you in the court of law, right? That's what they say when they arrest your ass, right? You need a lawyer. If you don't have a lawyer, we will appoint the lawyer for you. So now Bonjean is saying that the defendant does not contend, right? He's not saying, right? Contend is agreeing, right? A saying, contend, right? Let me double check that word just to make sure I'm using it right. Oh, okay. So it's a struggle to surmount a difficulty or danger. She had to contend with his uncertain temper. She had to struggle with his temper. It was difficult for her to deal with the danger, right? So another synonym is face or take on, resist or withstand. So the defendant does not struggle, right, that a Miranda violation will occur if his sentencing hearing proceeds before resolution of the Northern District of Illinois. So he's saying that this is not the case here, right? He's not struggling with that. That's not the issue. Okay, that's not the issue. But wasn't she talking about that before? But then she says, rather, the defendant argues that to provide fulsome mitigation evidence, he will have to waive his Fifth Amendment right. And that carries serious risk. So he's not worried about his right to remain silent. Anything he say can and will be used against him in the court of law. He's not fighting about that. He's fighting about a fulsome mitigation. Defendant argues that to provide fulsome mitigation evidence, he will have to waive his Fifth Amendment right. And that carries serious risk. Okay? So I don't know if you guys can see the other page. No, wait, I have to stop sharing this one. Why don't we ask the guy who came in second? All right. Okay. Now here it talks about mitigation evidence, right? So what is mitigation evidence? Mitigation evidence is critical to successfully representing a criminal defendant in any jurisdiction. These materials are substantive documents that document a defendant's good character, reputation, and achievements. So Miss Esquire had explained that to us, right? We understood that that's what it is. Somebody's going to come in and they're going to question him, right? A probation officer is going to question him. A mitigation expert is going to question him. And they're going to ask him about his good character, his reputation, and his achievements. And it says that mitigation evidence is such materials take many forms to include, but not limited to. Okay. These are the types of materials that will go into mitigation evidence. Okay. So he's worried about these types of things that are going to go into mitigation evidence, right? So the materials that I'm about to read, they take many forms, all right, and they are to include them, but not limited to character letters, right? So his friends will be writing letters, submitting character letters for R. Kelly, right? Also, proof of education, such as his degrees, his transcripts from school, and his academic awards, certificates, awards, and honors he received, in his employment information, and history such as his pay stubs, his tax returns, letters from employers, um, awards, bonuses that he earned, promotion and performance information, etc. His resume, things of that nature. Evidence of volunteer community services, substance abuse treatment records, mental health treatment records, medical records, or evidence of physical disability. Hey, so if he does have dyslexia, this mitigation evidence should hold that information. His medical records, his physical disability. If he had a disability and his mom took care of it, and he was actually labeled as having this disability, it'll be in there. Proof of military service, proof of charity work or contributions, photographs, and more. Mitigation evidence is the key to good criminal defense representation in most cases. When trying to negotiate a dismissal or a favorable plea deal, providing these materials to the prosecution enhances the ability to attain these goals. So he needs this type of evidence to help to reduce his sentence. Mitigation materials can also be provided to the judge for consideration on an ultimate sentence, either upon pleading guilty or after trial. They can also be used in the beginning of a case, such as at an arraignment or soon after when arguing for bail. So remember when they were taking those letters in from R. Kelly supporters? They were taking mitigation material. So those letters they're going to put in for sentencing. That's just what I think, right? For me, reading this and understanding this, I believe that they will use those letters as character letters in his sentencing, pre-sentencing report. They're going to put it in there. Then it says, okay, so yeah, such as an arraignment or soon after when arguing for bail, or even after a case has been closed, such as with representation before a parole board. A mitigation package containing many of the items referenced above permits a criminal defense lawyer to better humanize and educate others about the client. So, the goal of submitting a mitigation packet is to minimize the severity and seriousness of charged conduct for purposes of influencing an optimal case result. So, obtaining mitigation evidence requires the assistance of the defendant or family members. And once a defendant is arrested or summoned to appear in court, gathering these materials should be a top priority. If incarcerated, a defendant should designate a close friend or family member to assist with obtaining this information. The importance of having these materials as early as possible in a case cannot be undermined. So, once received, a lawyer can use this information to draft letters, bail memos, sentencing arguments, and more on the client's behalf. Doing so takes a lot of time and resources. As such, many lawyers do not subscribe to this practice. Oh, okay, we're not going to read that. Okay. All right. Okay, here we go. Let's see what else I had said. Okay, so the package includes statements of support from family, friends, employers, co-workers, clergymen, and more. His education, certificate awards, employment, performance evaluations, promotions, other employment accomplishments, resume. Okay, we said all of that. Yep. Oh, also, tasteful photographs depicting him with his family, his friends, and more in various aspects of his life. And any other information that highlights the positive qualities, attributes, and aspects of his life. So that's basically what it is. They're going to want to know all that stuff about him. Okay. So the argument is that being that he has to submit this mitigation package, right? He's saying that he will have to waive his Fifth Amendment right. Right? Okay. Okay. Now it says waiving the Fifth Amendment privileges. Okay. And the foundations of law for this is Miranda versus Arizona. Okay. That's the case law. So when they say, Miranda, it has to do with that law. Miranda versus Arizona. It was a case and it became case law. Filed, this is how they fought that case and how it was won or how it was lost. What statutes they used, all that stuff and things of that nature, right? So, in terms of waiver, a voluntary and intentional relinquishment of a known right. Waivers can be explicit. Express waiver or implicit, which is implied waiver. Now, an express waiver requires a writing or a statement of waiver. An implied waiver can occur simply by some action, where such action indicates one's intention to waive the rights. Okay? Then the act for an implied waiver must unequivocally indicate the desire to waive one's rights. I can't pronounce this. Cajolery, cajolery, an international. Excuse me, guys. Sorry about that. An intentional attempt to deceive or otherwise persuade a suspect through use of false promise or inducement so that he or she will waive or otherwise relinquish rights and respond to an interrogation. So, dissenting opinion. All appellate decisions, including Supreme Court decisions, are made by a panel of judges of 3 or more rather than by a single judge. Okay, so that's just explaining that. All right. Okay. So because the Fifth Amendment privilege against self-incrimination, as interpreted by the Miranda court, is a right that can be waived by the defendant, it is important to understand what constitutes a waiver for Miranda purposes and what are the consequences of such a waiver. A Miranda waiver will not be implied merely from a defendant's silence, and the prosecution bears the burden of showing that the defendant had waived his or her Miranda rights. Although a defendant can waive their Miranda rights expressly or impliedly, a court finding of an implied waiver requires conduct that evidence an intent to knowingly and voluntarily waive their rights. So, okay, I'm a little confused with that. All right, so no, this is okay. Wait.
Merchandising line for street dancers, hats, t-shirts, gloves. Anyway, Jesse was my best friend. You should have seen him. He tore up the stage. It was all part of the plan. Jesse rocked the crowd, became a star. I would amp the hype, kickstart a marketing campaign, he surprised me. You explain your fingerprint and crime scene? Yeah, I was there.
Kahoolery, I think that's what it is.
We all went back to the hotel to celebrate.
Okay.
Jesse booked the night. The party was on.
All right, so it says that it is important to note that Tedderman's actions, that's about the law that happened. The Miranda court held that the privilege is not waived if the individual answers some questions or gives some information on his own prior to invoking his right to remain silent. Okay, so a few years prior to the Supreme Court decision in Miranda, the court laid the groundwork for determining whether or not a defendant had waived his Fifth Amendment privileges. The court stated, the record must show, or there must be an allegation and evidence which show that an accused was offered counsel but intelligently and understandingly rejected the offer. Anything less is not a waiver. Okay. Okay, we're not talking about that because that's a count. Okay, so what does it mean to? Okay, it says here that. So, what does it mean to intelligently and understandingly waive one's rights in the absence of threats, trickery, or cajolery? Right? In California versus Stewart, one of the cases decided at the same time as the Miranda decision, police held 4 people, in addition to Stewart, the defendant, in jail for a period of 5 days, during which time they were interrogated. One of these was Stewart's wife. Oh. These were not defendants in the case, but happened to be present when Stewart was arrested. At the end of 5 days, when Stewart confessed, his wife and the others were released, and the police indicated that they had no evidence connecting these 4 with any crime. During the 5 days, Stewart was interrogated 9 separate times by police, and except for the first session, Stewart was always alone in the room with the police. According to the court, there was no indication that Stewart was ever advised of his rights. So in Stewart, the waiver of rights, if any, certainly was not made intelligently and understandingly, but rather in response to repeated interrogation and the imprisonment of his wife and associates. Clearly extended interrogation combined with the coercive nature of having one spouse kept in jail makes voluntary waiver highly unlikely. Yeah, I mean, if there was no evidence or anything like that, and he waived the right, but he didn't waive the right. They just did what they had to do voluntarily.
When you're
Wavering
done
it.
with your live stream, can we go to CVS so I can get the gift card?
Oh, yeah. Okay. Let me see here. What else am I? Let's see.
Here.
So his friends, family, or whoever is scared of incriminating themselves. They don't want to get in trouble with R. Kelly, too. So he'll have to waive his Fifth Amendment right. Because he doesn't want to incriminate himself if he speaks about things. Because they're going to want to know everything. And that stuff can be used against him in the court of law. So he will have to waive his right to remain silent. And they're saying that that carries some serious risk. He could be vulnerable to them, questioning him to the point to where he can incriminate himself. And that they could use that against him in the other trial. So he's saying that it is fundamentally unfair that he should have to make that choice when so much is at stake. So when he says that so much is at stake, he's saying merely to remind the government that any statement can be incriminating if the prosecution decides to use it for some reason. So defendant was not suggesting that his Miranda rights were in jeopardy. Like, that makes no sense. How are you? It makes no sense here. So then in the second part, it says that second, that the defendant appreciates that all defendants who have been convicted of an offense run the risk of self-incrimination when they participate in the sentencing process. So she's saying it's not about what he said in the beginning before he got arrested. It's more about what he's got to say later on, now that he's going to be sentenced, that he could be running self-incrimination. So she said, but this case is unique and distinguishable from De La Paz. Now, okay. All right. So De La Paz versus State of Texas. Let me show y'all what that is.
To be your hero.
What's up, Papoose? It's all right, guys. She could come in here. You timed her out. That's fine. It's cool, Pap. You can come over here and you can say your thing. It's all right. You already know. If you get crazy, you already know that the girls, they're going to want to chop you up. I'm not in the chat. I have no control of that shit. So, hello. Thank you for stopping by. So, yes, he should have rights, of course. Everybody. I mean, I'm not saying anything about that at all. I'm just trying to break it down and explain what all this means. I ain't trying to say that his rights, he ain't got to have rights and they should be taken away. And I'm not saying none of that. And we ain't screaming that over here. We're just giving facts, honey. That's what I do over here. You do shits and giggles. I do facts. Okay? And I'm still confused as to why you tagged me in a post on Twitter, but then blocked me so I can't see it. Like, that was really weird. Yeah, that was weird. Really weird. Like, strange. Hmm. So now, in De La Paz versus State of Texas, this is the Court of Criminal Appeals, right? And okay. Let me see. I'm trying to go to okay. The trial court admitted certain hearsay evidence over appellate's objection that its admission would violate his Sixth Amendment right to confront the witnesses against him. Now, on direct appeal, the Court of Appeals held that the trial court did not err in admitting the evidence. We now reverse and remand. So on October 18, 2005, a Nolan County grand jury returned an indictment charging appellant with 2 counts of aggravated sexual assault of a child under Texas Penal Code 22 da 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 da. Now, count 1 of the indictment alleged that appellant penetrated the child's female sexual organ with his finger, and count 2 alleged that he penetrated her sexual organ with his penis. So, on March 27th of 2006, the state brought appellate to trial before a petit jury on his plea of not guilty. At the guilt stage of the trial, the state called 6 witnesses: Angie, Tonya, Matt, Les, Pat, Michelle. The state also offered in evidence numerous exhibits. Appellant called 4 witnesses: Angie, Melissa, Irene, and himself. Now, Angie, when called to the witness stand by the state and later by appellant, testified that 1, she was 25 years old and resided with her 5 children. 2, on the day in question, Saturday, May 14, 2005, appellant, her longtime boyfriend, and the biological father of her children also resided with her and her children at that address. 3, her children included 3 girls, KD, CD, and FD, and 2 boys, MD and OD. Now, 4, on the day in question, KD was 7 years old, CD was 6 years old, MD was 6 years old, OD was 4 years old, and FD was 2 years old. Now, 5, on that day at 3 p.m., she left her children at home alone with the appellant, while she accompanied her mother and niece to a nearby Walmart store. 6, she returned from the Walmart store at about 3:50 p.m. and found the front door locked. 7, she knocked on the door and appellant opened it. 8, she entered the residence, put her purchases on the table, and then went back outside to check on the children, who were all playing there. 9, she then went back inside the residence to use the bathroom. 10, appellant accompanied her into the bathroom, and the 2 of them conversed there. 11, appellant told her that while she was gone, he had bathed the children. 12, appellant also talked about what would happen if one of the daughters got molested. 13, she and appellant then heard a knock at the front door. 14. Appellant went to the front door and opened it while she remained in the bathroom. 15. She heard appellant saying, I told you not to be playing outside. 16. She then left the bathroom, at which point appellant told her that KD was bleeding at her middle spot. 17. Appellant also said that KD had told him there was a black guy. 18. She examined KD and found bloody toilet tissue in her underwear. She removed the bloody tissue from KD's underwear and put some more in it to make it stop bleeding. 20. She asked KD what happened to her, but KD would not say. 21. She, Medina, then telephoned her mother to ask for a ride to the local hospital. The appellant didn't want her to take KD to the hospital. However, because he was afraid that they would get the kids taken away. 23. The appellant was worried specifically that the cops and CPS would get involved. 24. She told appellant that she had to take KD to the hospital because she was bleeding a lot. 25. Her mother drove her and KD to the emergency room of the local hospital. While at the hospital, she telephoned the appellant back at their residence in order to check up on the other kids. She spoke with the appellant briefly at that time. What was that, mate? Wait. Okay. She spoke with the appellant briefly at that time. And then he put 6-year-old CD on the telephone. 28. She could hear appellant in the background coaching CD to tell her that KD had fallen out of a tree. KD was later transferred to a hospital in Abilene. And KD was released from the hospital in Abilene on Tuesday, May 17, 2005. Medina also testified that in April of 2005, appellant had caught her having sexual intercourse with another man. State's witnesses, Tanya Sides, testified that she was a child abuse investigator and certified peace officer employed by the Nolan County District Attorney's Office. And then on May 14th of 2005, she was called to the Rolling Plains Hospital in Sweetwater to investigate a possible case of child abuse. While at the hospital, she spoke with Angie Medina and learned that Medina had given consent for a police search of her residence. She then drove to Medina's residence and participated in a search of it. When she arrived at the residence, appellant and appellant's mother and a few of his children were there. During the search, she found a pile of wet, blood-stained clothing in the bathroom. She also found some toilet tissue in the trash that had blood on it. While at the residence, she requested that appellant go to the police department and talk with the police about KD's injuries. And appellant agreed to do so. Later that day, while talking with appellant at the police station, she explained to him that he was not under arrest and that he was free to leave at any time. An appellant then gave a statement which was reduced to writing and signed by him. Appellant's written statement admitted in evidence as State's Exhibit Number 1 reads as follows. Angie and I were in the house. Angie was in the restroom and I was in the kitchen fixing a sandwich. While I was fixing the sandwich, Angie said, "Who's knocking on the front door?" I told her that I didn't know. I went to the front door and nobody was there. I heard somebody start knocking at the back door. I went to the back door and saw KD standing there. She had her hand out and I could see blood on the tip of her fingers. KD told me she was bleeding. I asked her where she was bleeding from, and she told me down there. I pulled out her shorts and could see blood. Angie asked what was going on, and I told her. Angie called her mom and asked her to take them to the doctor. We asked KD what happened, and she just told it was a black boy. I asked her which black boy, and KD told me that she did not know. I asked her what happened, and she just said it was a black boy. CD told me that KD had fell out of a tree. KD told me that she didn't fall out of a tree and that it was a black boy. Angie's mom showed up and they took KD to the doctor. Sides testified further that on May 17, 2005, she drove back to the residence and placed the appellant under arrest. She transported him to Nolan County Jail, where she advised him of his Miranda rights, and where he voluntarily gave a second statement, which was different from his first statement. So the appellant's second statement was also reduced to writing and signed by him. And she did not coerce appellant or promise him anything in return of his second statement. Appellant's second written statement, admitted in evidence as State's Exhibit Number 2, reads as follows. On Saturday, my wife went to the store with her mother. She left me with 4 of my kids. I was going to take them a bath. I put the 2 girls, CD and KD, in the bath. I told the boys to wait for the girls to finish so they could take a bath. I had to put shampoo on their hair and around their neck and armpits and arms. They were jumping around and stuff in the tub. KD had soap in her eyes and she was crying. I was like mad. I reached down by her legs and pulled her hard. I did not have this planned. I didn't plan to go to her private. I guess that is when I cut her open. I had seen blood when I grabbed her. I could feel part of her private. After I seen blood, it scared me. So I got them out of the tub and cleaned her up. I told CD to go in the other room and change because I didn't want to see it. I didn't want her to see it. I used toilet paper to clean her up. I got underclothes and I put them on her while we were in the restroom. I told her to walk out like that and change into her other clothes. From there, they got dressed and I combed their hair. I told them to play outside. I was scared. I didn't want to end up in a place like this. I didn't know what to do. After that, that is when they went out to play, and I took the boys a bath. My wife got home, and we went into the restroom. KD was knocking on the front door. My wife asked who it was, and I went to the back door, and I opened it and saw blood on KD's hand. She was telling me that she was bleeding from down there. From there, we went to the room and started cleaning her. And my wife told me she was going to call her mom to take her to the doctor. I never told her not to call the police. The only thing I did was get scared when I seen the blood from my little girl, and I told her not to tell what happened. My wife pushed toilet paper in my daughter's private. I love my kids a lot. I love my daughter, and I would never do anything to hurt her. What happened was an accident, and it wasn't anything I planned. I love them all with my heart. I wish none of this happened. Oh my God. Wow. So she cited this law. So, state's witness Matt Counts testified that he was an officer in the Sweetwater Police Department on the afternoon of May 14, 2005. He responded to the call from the emergency room of a hospital in Sweetwater. When he arrived at the emergency room, he took possession of the clothing that KD was wearing when she arrived there. State's witness LaSouls testified that he was an officer in the Sweetwater Police Department on the afternoon of May 14th. He responded to a call from the emergency room of the hospital in Sweetwater. When he arrived at the emergency room, his superior there ordered him to secure the scene. He went to the residence and made sure that the scene was not contaminated from that point. Upon his arrival at the residence, he explained to the appellant why he was there and asked the appellant and his two children to step out onto the front porch, and they complied. He asked the appellant for permission to search the residence, and the appellant gave his permission. During his search of residence, he noticed that the bathtub was dry, had no moisture in it, with gritty, dry type sand in the bottom. The fact that the bathtub was dry seemed significant to him because appellant had told him that he had tried to clean the little girl up, and appellant told him that he didn't know how KD had been injured. All right, let me get some more water, y'all. Give me a second. Okay. The state's witness testified that she was a gynecologist. Someone named Pat testified, and she was a registered nurse at the hospital. Now, the state witness, the registered nurse, said that she examined her in the emergency room, the little girl. Whenever she asked what happened, the little girl, KD, would just calm right up and get real scared. And that KD had a life-threatening second-degree laceration in her vagina. The injury required surgical intervention and was unquestionably caused by a sexual assault. And the injury was not consistent with the fall. Now, remember, his daughter KD was how old? Our children include 3 girls. Okay, so KD was 7 years old. So this is his 7-year-old daughter that had a laceration in her puna nunu. In her little nuni. Okay.
Coming Friday too.
Oh God. Are they gonna set that up too?
No, that's just gonna be in boxes. I gotta set that up.
No, okay.
That'll be in boxes.
Okay.
But no, what's gonna be set up is the gazebo.
Okay, good. Yay!
So Easter Sunday. It'll be set up for Easter Sunday.
Yay! We're barbecuing or something?
No.
Oh, just hanging out out there. Okay.
Barbecue ain't here.
Okay, yeah, that's what I was saying. Okay.
We can hang out up there. Remember, there's no more eggs. Easter Sunday. She's gonna put eggs around. So
Right.
we'll be able to sit over there too.
Right.
Relax.
Okay.
Try it out.
Yes. All right. Awesome, Mom. Sorry about that interruption, guys. Sorry. So the gynecologist said that it required her to get surgery. And that at the time, the little girl was unable or unwilling to give any information regarding her injury. And that the laceration in the area went into the deeper tissues, not just through the skin, and required surgery to repair. Now, her injury was consistent with penetration by an adult penis and was probably not caused by a fall. The state also mentioned previously that they offered in evidence numerous exhibits, including her medical records, KD's medical records from the hospital, and another medical center, and that those medical records introduced as state's exhibits number 10 contained, among other things, 3 sets of notes handwritten by 3 medical center employees, in which notes those employees described how KD, in their presence, had indicated that appellant had caused her injury. So the appellant timely objected to the omission of the handwritten notes on 2 legal grounds. First is that they contained hearsay within hearsay and were inadmissible under Texas Rule of Evidence 802. And second, that they contained several testimony hearsay statements allegedly made by KD that were inadmissible under the Sixth Amendment's Confrontation Clause. So the appellant cited Crawford versus Washington in support of his constitutional argument, and the state responded that the notes were admissible under Texas Rule of Evidence 803, Section 4, the medical diagnosis exception to the hearsay rule. So the state perhaps inadvertently made no effort to establish that the notes were admissible under the Confrontation Clause. So the trial court overruled the appellant's objection and admitted the notes after ordering certain parts redacted. The state read the notes to the jury shortly before resting its case in chief. Kind of like what they did with the videos before they rested their case in R. Kelly's trial. They added the videos and all that stuff, and also the uncharged acts, towards the end, right? Now, the first set of notes dated May 16, 2 days after appellant became a suspect, and written by Melissa Foss, a social worker at the medical center, reads as follows. Reviewed chart and spoke with charge nurse regarding unintelligible of vajayjay laceration and alleged S assault. Went to room to talk with patient. Mom present in room. Asked mom to talk with patient for a few minutes in private. Mom went to a family room. Began conversation with patient, talking about school, and she told me all about her school, teacher, and friends. I then asked the patient about what happened on Saturday before she came to the hospital. She stated, I'm bleeding and daddy gave me a bath. When asked why she was bleeding, she stated, daddy poked me. When asked what she was poked with, patient stated his fingers. I then asked patient, did daddy poke you with anything else? Patient stated, with his pee-pee. I then asked patient, has he done this to you before? Patient replied, a lot. I asked patient if her dad also did this to her brothers and sisters. Patient shook her head no and stated, just me. I called out to the nurse's station for a charge nurse RN to be a witness. Casey asked patient, can you tell me what happened? Patient looked at the floor and stated that he poked me with his pee-pee. I asked patient what else? Patient stated with his fingers. I asked patient, where was your mom? Patient stated at the store. Casey left room and I told patient I needed to make some phone calls and would check on her later. Met with mom to discuss conversation with patient. Asked mom if patient had told her what had happened. Mom shook her head yes and told me how her husband acted very funny when she got home from the grocery store. Per mom, dad bathed patient, which he never does per mom. She said he never washes her and was not concerned with the amount of blood loss. Told mom to wait until Monday to take patient to the doctor. Mom decided to go ahead and take patient to the hospital because 6-year-old daughter told her something bad happened to the patient. Contacted CPS caseworker and a detective from the police department, Tanya, to discuss and form the conversation with the patient. Okay. The second set of notes, written by the other nurse, her other note by the same nurse, more notes, said that they called to patient room. The social worker's mom was outside the room. The social worker was outside with the mom. And the social worker asked the patient, "Can you tell Miss Casey what you just told me?" I asked the patient, "Can you tell me what happened?" The patient looked down at a pen she was holding and stated, "My daddy poked me when asked myself with what." Okay, so they just, okay. Mom called out stating patient wanted to speak to us. Patient up in bed coloring. Patient states, "I saw blood." I asked, "Where did you see the blood?" Patient stated, "In the toilet." And then she was also asked, "Where else?" Patient stated, "In the tub." And then she said, "Did you take a bath before or after you saw the blood?" Patient stated, "After." "Do you know how the blood got there?" Patient stated, "No," and nods her head. At this time, Dr. Johnson enters the room. Patient ceases talking. Poor baby. Oh my God. I'm trying to get to the point. Like, this is really a lot. So, okay, so in the brief, the state argued that KD's hearsay statements were non-testimonial because the statements were made to medical personnel and not to law enforcement. So the state also pointed out that law enforcement was not present at the time of the alleged statements, nor did they request the interview. The state argued further that in any case, it would be speculative to support that KD made the statements with any intention that they affect appellant's criminal prosecution. Finally, the state argued that even if the trial court erred in admitting the objected to handwritten notes, the error was harmless beyond a reasonable doubt because the evidence against appellant was so strong that KD's hearsay statements could not have contributed to his convictions. Now, the 11th Court of Appeals rejected appellant's argument and affirmed the judgment of the trial court. De La Paz versus State. The Court of Appeals explained its holdings as following. In another case called Crawford versus Washington, the court held that the admission of testimonial hearsay violated the Sixth Amendment right to confrontation unless the declarant was shown to be unavailable to testify and the defendant had a prior opportunity to cross-examine the declarant. The Supreme Court did not provide an exclusive definition of testimonial statements, but did hold that the confrontation clause applies to witnesses who bear testimony, which it noted is typically a solemn declaration or affirmation made for the purpose of establishing or proving some fact. Their notes, the two nurses' notes, arguably raised two potential confrontation clause questions. Did KD really say what they wrote? And if so, are her accusations accurate? When the notes are stripped of any personal observation or third-party comment, there remain evidence that KD implicated her dad to hospital staff, but not evidence that KD's accusations were true. The jury was tasked with determining whether KD's accusations were accurate, not if the recorded conversation took place. So KD's accusations were certainly relevant to the jury's determination. However, their bare repetition does not fall within the Supreme Court's definition of testimonial statement. Therefore, De La Paz's inability to cross-examine Foss and Wasson did not violate his right of confrontation. Appellant later filed a petition for discretionary review, which we granted. In their briefs to this court, both appellant and the state reiterate the arguments that they made in the Court of Appeals. The state also argues that the Court of Appeals analysis is sound. Okay, so this is about a confrontational clause of the Sixth Amendment to the Constitution. Provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. This bedrock procedural guarantee applies to both federal and state prosecutions. Pontier versus Texas. Consistent with the confrontation clause, guarantee a testimonial hearsay. Okay, but it doesn't say anything about his Fifth Amendment right, which is what she's arguing, right? Wait, let me go back to the paperwork. Second, defendant appreciates that all defendants who have been convicted of an offense run the risk of self-incrimination when they participate in sentencing process. But this case is unique and distinguishable from De La Paz. First, defendant is not seeking a continuance of his sentencing hearing merely so he can exercise his right of allocution, although his right. Now let me see what the allocution means. Hold on. Okay. So allocution, okay, so the concept of allocution. An allocution allows the defendant to explain why the sentence should be lenient. So in plea bargains, an allocution may be required of the defendant. The defendant explicitly admits specifically and in detail the actions and their reasons in exchange for a reduced sentence. So in principle, that removes any doubt as to the exact nature of the defendant's guilt in the matter. The term allocution is used generally only in jurisdictions in the United States, but there are vaguely similar processes in other common law countries. In many other jurisdictions, it is for the defense lawyer to mitigate on their client's behalf. And the defendant rarely has the opportunity to speak. The rights of victims to speak at sentencing is also sometimes referred to as allocution. Okay. In most of the United States, defendants are allowed the opportunity to allocute before a sentence is passed. So some jurisdictions hold that as an absolute right. So in its absence, a sentence but not the conviction may be overturned. In its absence, a sentence but not the conviction may be overturned. So she's trying, in other words, she's trying to get his sentence, his conviction, a sentence but not the conviction overturned. So she's trying to, Bonjean is trying to get rid of his conviction. She's trying to ask for a new trial. And she's also trying to get his sentence overturned. It says, resulting in the need for new sentencing hearing in the federal system. Federal Rules of Criminal Procedure 3214 provides that the court must address the defendant personally in order to permit the defendant to speak or present any information to mitigate the sentence. The federal public defender recommends that defendants speak in terms of how a lenient sentence will be sufficient but not greater than necessary to comply with the statutory directives set forth in 18 U.S.C. 3553A. So, first defendant is not allocution, allocution, although his right of allocation is unquestionably compromised if his sentencing proceeds before the Northern District, Illinois case. Rather, defendant seeks a continuance so he can speak more freely to a mitigation expert about his own history and develop evidence that may shed light on the offense. So yeah, she's strategizing. She's trying to get this so that if he gets sentenced, if he gets convicted in, I see her strategy. She's trying to change his sentencing. So if he gets convicted in the Northern District of Illinois, like I said, she's going to try to see if maybe they run all concurrent, and then she's going to try to, if anything, reduce his sentencing. So it'll be easier if he gets to get sentenced for both cases more or less at the same time, so that it's not violating his right to criminate himself, basically. So maybe it might be better. My opinion, maybe it might be better. Because then, like she said, they can run all the sentences concurrent, and then ask for a lighter sentence on all of it, all together. And that his friends are fearful of writing letters or making statements for him because they could be incriminating themselves as well. You know, like what is said before, with that his family members were all locked up. They were all in jail for a little bit of time until they sorted out everything. They don't want that kind of stuff happening. Like, that's not going to happen. That's ridiculous. But whatever. So, Okay. So the right of allocution appears at the federal level in the first version of the Federal Rules of Criminal Procedure, published in 1946, and it has evolved slightly over time, especially following a Supreme Court ruling in 1961, Green versus United States, in which court ruled that it was not enough to offer the defendant's lawyer an opportunity to speak. So it's in cases in which defendants face possible death sentences. So the failure to ask defendants directly if they had anything to say prior to sentencing constituted a basis for reversal. So by the 17th century, American courts sometimes permitted and sometimes required allocution, but there was no general agreement about when allocution rights were required or how they should be exercised. But the practice flourished in the United States as it was not limited to capital cases. So, it might seem unusual in today's digital age, but allocution statements almost always originate as handwritten documents, typically 1 to 3 pages in length. So the federal rule does not specify whether the statement should be presented in writing to the court or spoken directly to the judge, but at the federal court level, the statement is generally handwritten. This is due in part to practical reasons. The defendant may lack access to a typewriter or computer, but handwriting actually tends to reveal more about the individual. The example here showcased this, as the handwritten version exhibits penmanship, crossed out words, spacing, and lacks punctuation that was included in the typed version. So sometimes it is not practical to include a handwritten statement. If a defendant has injured his or her hand, for example, in these cases, typed statements are arranged. In either circumstance, handwritten or typed, the statement is filed in the court with case number, parties, and date stamped or attached. What do the statements actually say? That varies from defendant to defendant, but typically the defendant's lawyer will advise the defendant what to consider or include. The lawyer might provide a list of questions for the defendant to address, such as, what are your best accomplishments? What are your best attributes? What are your long or short-term goals? What is a just punishment for your offense and why? How would leniency in sentencing promote your respect for the law? How would you benefit from educational or vocational training? How would leniency provide you with additional training? How would giving you leniency protect the public from additional crimes committed by you? In the excerpted example here, the defendant's statements includes personal goals and reasons for self-improvement that might benefit others besides the defendant. Now, allocution statements may or may not have an effect on sentencing, depending on the case, the crime committed, or tone of the statement. So while it is difficult to say with certainty, when federal judges were surveyed in 2014, they indicated that overall, they are hesitant to lower or increase sentences based on allocution. Certain crimes, however, elicit trends in sentencing, regardless of allocution. So, for example, judges seem less likely to lower sentences for crimes involving child pornography, while low-level drug crimes and white-collar crimes inspired them to consider mitigating factors in sentencing. Well, so all this arguing about this allocution statement, this statement that R. Kelly's supposed to make, it might not even matter at the end of the day what the hell he got to say on there. Because at the end of the day, judges seemingly are less likely to lower sentences for crimes involving child pornography. I would gather with anything that has to do with children. So in the Chicago case where there is child pornography in there as well, even though this case wasn't based on child pornography, but they spoke about child pornography, the child pornography is in the Chicago case. His sentencing won't be reduced at all because of that over there, period. That's not happening. So interesting. So when we talk about a continuance, right? Sometimes the defendant will seek a continuance when they are changing their attorney. Now, they have a Sixth Amendment right to choose their own attorney. So a judge may grant a continuance if the defendant can show that changing their attorney is necessary. So, in spite of this general approach, both the defense and the prosecution in a criminal case and the court on its own motion may ask for and obtain a continuance, beginning with the defendant's first appearance, which is typically the arraignment, where the defendant is appraised of the charges and asks how he wishes to plead. Okay, so good cause for a continuance in court: the incapacity of the defendant, counsel, or the court. The defendant's or counsel's illness is good for a continuance, though the court may demand proof, including medical testimony. Note that this reason does not usually extend to prosecutors. See below. They are expected to find a replacement from their office. Okay. Why would a court-appointed attorney request a continuation? Okay, let's see. Okay. All right, so grounds for a continuance. It would be for inadequate time, changing indictments, changing attorneys, or a surprise. So, sometimes the prosecution or the defense in a criminal trial discovers that they will not be ready to present their case properly at the scheduled time. So either side can ask the court for a continuance, or the judge can order a continuance independently if they feel that it is necessary. So judges generally do not grant continuances freely unless proceeding to trial would violate the defendant's rights. They have discretion to deny a continuance unless the law in their state requires a continuance to be granted in a certain situation. So these are the certain situations for the continuance: inadequate time, changing indictments, changing attorneys, or a surprise. Now, a determination on continuance usually comes down to whether the party seeking the continuance has acted with proper diligence in preparing their case. If a defendant decides to hire a lawyer or change their lawyer, for example, they should do this promptly. The party seeking the continuance needs to have made reasonable efforts to move the case forward, although they do not need to have done everything possible to develop the case to get a continuance. All right. All right, so continuance based on inadequate time. Now, what was she, her continuance is for what? Understands that his sentencing hearing cannot be postponed indefinitely, nor does he ask that it be continued until resolution of every state court criminal and civil matters he faces. He merely asks that in light of the serious federal prosecution that is scheduled to commence on August 1st, this court grant a slightly longer adjournment. So, okay.
Maybe at a chill spot picked up and get it there first. Figured you hide the body in the shipping drum until then. There's a way station about 30 miles back.
So continuance based on surprises. If the prosecution announces that it will introduce new evidence or new witnesses who were previously unknown to the defense, this will be a strong basis for a continuance. The defense also may seek a continuance if it is unable to locate a witness who was expected to testify on the defendant's behalf. A judge may be reluctant to grant a continuance if the defense still has sufficient time to prepare, or if the evidence is related to evidence that had been disclosed to the defense. A judge may grant a continuance during a trial if a witness for the prosecution provides unexpected testimony that the defendant could not have anticipated. If the defense can gather contradictory evidence within a reasonable time, the judge likely will provide an opportunity to do so. However, a defendant probably will not get a continuance if their own witness provided unexpected testimony. Okay. So, what does a mitigation specialist do? A mitigation specialist. Wait, let me see something. Okay, so the American Bar Association, expressly recognized the critical role of the mitigation specialist in capital litigation. In its 2003 revision of the guidelines for the appointment and performance of defense counsel in death penalty cases, the ABA sets forth in Guideline 4.1 that the defense team and supporting services that the defense team should consist of no fewer than 2 attorneys qualified in accordance with Guideline 5.1, an investigator, and a mitigation specialist. The accompanying commentary states that a mitigation specialist is an indispensable member of the defense team throughout all capital proceedings. Mitigation specialists possess clinical and information gathering skills and training that most lawyers simply do not have. Now, they have the time and ability to elicit sensitive, embarrassing, and often humiliating evidence. For example, family sexual abuse that the defendant may never have disclosed. They have the clinical skills to recognize such things as cognitive, mental, or neurological conditions, to understand how these conditions may have affected the defendant's development and behavior, and to identify the most appropriate experts to examine the defendant or testify on his behalf. Moreover, they may be critical to assuring that the client obtains therapeutic services that render him cognitively and emotionally competent to make sound decisions concerning his case. Perhaps most critically, having a qualified mitigation specialist assigned to every case as an integral part of the defense team ensures that the presentation to be made at the penalty phase is integrated into the overall preparation of the case rather than being hurriedly thrown together by defense counsel, still in shock at the guilty verdict. So, the mitigation specialist compiles a comprehensive and well documented social history of the client based on an exhaustive investigation, analyzes the significance of the information in terms of impact on development, including effect on personality and behaviors, finds mitigating themes in the client's life and history, identifies the needs for expert assistance, assists in locating appropriate experts, provides social history information to experts to enable them to conduct competent and reliable evaluations, and works with the defense team and experts to develop a comprehensive and cohesive case in mitigation. The mitigation specialist plays an important role as well in maintaining close contact with the client and his family while the case is pending. The rapport developed in this process can be the key to persuading a client to accept a plea to a sentence less than death. So he might just take a plea deal to lessen his sentence, guys. Let's see if that happens. Larry Nassar did it, but he still got 140 years anyway. So is it really going to matter in this case? I don't think so. I don't think so. Now, for all these reasons, the use of mitigation specialists has become part of the existing standard of care. Okay. And they are high quality investigation and preparations of the penalty phase. Um, okay. Okay, that's that. Okay. Now, the Fifth Amendment um, 2/3 of the House, both houses shall deem it necessary, shall propose amendments to the Constitution or on the application of the legislators of 2/3 of several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of the Constitution when ratified by legislators of 3/4 of the several states. That's where we were right now, right? Okay. Um,
He's an animal. You gotta do this with him.
I'm just trying to see here, guys. I'm sorry. I'm just kind of scrolling through a little bit to see what's good on this. Um,
Her name is Madeline Briggs. When I ran the prints of the DNA I lifted off the jug I found in the sleeper compartment, I got a hit to a missing girl out of Miami. Her mother filed the claim 5 days ago.
So we have to assume Steele picked her up in Miami and drove her up to the
all right. I'm just gonna leave that there.
Her analysis revealed traces of sedative propofol. I'm thinking that's what they used to keep her under control.
All right, guys. I'm gonna see what you guys are saying. Give me 1 second.
That's because she's fighting for two.
Madeline's pregnant.
Yeah, her urine analysis also revealed traces of human chorionic gonadotropin, HCG.
Boss, I ran the rest of the prints, so we left you to sleep for care.
Madeline Briggs, right?
She was there too.
What do you mean?
I found evidence of more than one woman in that sleeper.
How many?
A lot. When I realized I had multiple donors, I ran the prints through every database that I knew of. I got this in through NAMUS, National Missing and Unidentified Person System. This one's from Florida, North Carolina, Philadelphia, Atlanta. These girls are from every state.
And all of them, one time or another, in case you steal his truck.
That's our chain down.
Someone here.
Deputy Miranda's out. Back. Got a Dr. Ray Langston home with a bid call. He's a CSI from Vegas. He's working a case in conjunction with Miami PD. Says that he picked up one of our entries and has some information on Madeline Briggs.
Okay, guys. Let's see what you guys are saying. Let me see what I could, as far as I can go up. All right, let's see. Okay. Hey, Miss Mo. What's up, baby? What's up, Ruby? Hey, Ruby. What's up, lady? Okay. Okay.
48 hours ago, Tyler was found shot to death in the bathroom of a truck stop in Jackson.
Okay.
Bill was clean. It was a bro job.
So Tyler hands off Madeline to Casey and gets paid with a bullet.
You have ballistics on that shooting? We do. Evidence of 45. I'm sending you our ballistics evidence right now.
Okay. Hey, Kayla. I just say hey to her, right? SK, T-Bam, what's up, ladies? Aisha. Right. If he's innocent, why so worried? Really? I also don't believe him due to the fact that he gave all that money and bought his alleged abuser a house. Oh, wow. Who were we talking about that did that? Okay. Yes. Thank you. Get those likes up. Okay. Let's see. I don't disagree at all that he did all that shit indisputable. Billie Jean has to throw out anything that will help get him a lighter sentence. I hope he has to allocate to everything he did. Basically, as we know, he sure does. But to be fair, several of Rob's victims went back to him. That doesn't mean that they weren't abused. Exactly. That does not mean anything. You know how many times a woman returns to her abuser before she actually leaves him finally? Anywhere between up to 7 times. It happens. Those are the statistics. Those letters, though, they never let it, but no, he's a good guy. Oh, the letters, right? Those letters. But they never met him, right? They never met him, but they know he's a good guy, and they're gonna act like that's their friend. Get the hell out of here. Tick, I know what you're saying, but if it was something that happened to him as a child, then as an adult came out, then appeared to pay her off, is not the same as going back to a relationship. Well, if they left and went back, I mean, regardless of whatever, it's still going back and forth. I mean, whatever. Sounds like it might behoove his supporters to focus on helping him focus on mitigation strategies and future appeals versus YouTube beefs and the survivors. No. Yeah. Okay. Don't sound like he was proactive with receiving any help physically or mentally. Sounds like he has more bribing to do to get fake letters. Ah, good point, honey. You're allowed your opinion and I'm allowed mine. Yes, we all are. Miss Mimo, I don't think they would accept this stuff. They're looking at character before arrest, right? They're looking at his character, basically his all-around character from childhood all the way up until present day. They want him to admit his shit too, you know. So that's why that's a problem, because if he allocates to his crimes, right, then he would be putting himself at risk to violating his right to remain silent with a lawyer. You know what I mean? Like, he will be violated his Fifth Amendment right if they use those statements against him in the other trial. So they're trying to be careful with that. So hopefully, we know Judge Donnelly knows what she's doing. Hopefully she makes the right decision, you know? Good afternoon, Samara. Good afternoon, honey. All that shit is going to find its way into those hearings and fuck him all up. Based on what this is saying, mitigating factors could be the ticket to getting him the least restrictive sentence possible. I'm shocked his supporters haven't focused on this element more. Of course not, because they don't know how to read the paperwork. They don't know how to read the paperwork and break it down. So they're just reading to read. They're not really researching and comprehending what they're reading. They're not. Especially Miss Sly Fox. She got people all confused over there. Oh my God. I cannot. I feel like his real supporters have been. It's the ones on the tube looking to build channels who are perpetrating all the fuckery. I agree. The aggravators can outweigh the mitigator facts. Hey, Ducka. Hey, Angie. Absolutely, you are right. Okay, we went to Pap. Okay. But you innocent but won't speak. Typo. What's she doing over here? Where she came from? Right. I come out the meeting in peace and am still listening. Hey, all my beautiful people. Hey, Rockin' Robin. What's up, baby? Why y'all block at one Paps? Oh, why y'all block one Pap? I don't think they blocked her. I think they just timed her out. They didn't block her. She didn't say anything bad. They just timed her out. Don't worry, shooter. It's okay. It'll be all right. If she's blocked, I'll unblock her. It wasn't that serious. Tasha the Gutter. Thank you, guys. Yes, please get them likes up. Don't let shooter in at all. You guys are terrible. I love you. This has nothing to do with Larry and victim bashing. Will not be tolerated at all. Yeah, come on. We're not discussing Larry over here. We're discussing paperwork and facts. We don't do the shenanigans over here, okay? We don't. Y'all want to fight? We'll take it to fucking Tears channel, okay? We're not doing that over here. Over here, it's about work. Over there on Tears channel, it's about expression and passion and our opinions. And she talks about paperwork because she knows her shit. She knows about the case. We are keeping our foot on R. Kelly. That's it. That's all. That's all we're concerned about. The case. We're not concerned about all this other shit going on YouTube. That's not our drama. Not our problem. Yes. Thank you, Peter. I came out the bushes when I heard her name. Don't say. It's okay. Pap could come over here. She's nice to me in a way. She lets me rock over there on her channel. I'll let her rock over here. Yeah, no. She gets crazy, then y'all know what to do. Other than that, I'm free will over here, guys. It's okay. You could come in, say what you got to say, as long as y'all not disrespectful. That's it. That's all. Like I said, my girls block you. That's not my fault. That's not my fault. That's not my problem. But I will unblock you. And if they feel like blocking you again, that's just what it is. I'll unblock you again. But y'all going to have to keep walking around the block a few times. That's just what it is. My mods over here protect me. And that's just what it is. Hey, Miss April. Okay, let's see what else. You used to live out there, Jackie? Okay, Tears. Okay, unless RSK said something when he was arrested, it seems irrelevant. Right, he did. They did do a pretrial questioning with him. Remember that he didn't admit that he was married to Aaliyah. He forgot to say he was married to Aaliyah. He only said, when they said, "Have you ever been married?" And he was like, "Yes." Who were you married to? Andrea Lee. And how long? 12 years, 13 years, something like that. Oh, okay. Any other marriage? No. Never been married ever. Nope. Just her. You lying sack of shit. They were like, listen, no, you were married to Aaliyah. Remember her? Do you remember her? Yes, exhibit 1. Jane Doe number 1. You married her, right? Oh, yeah, I forgot about that. Oh, how we have such a foggy memory. No, but I kept getting an error. Okay, she's talking about the thing. Okay, I don't know what's going on with that error thing. That has nothing to do with me. That has to do with YouTube. Take that up with YouTube, please. Oh, okay. Hey, Sharice, what's up, mama? Hey, 504 girl, what's up, baby? I'm getting server error. Okay, that's weird. That's really weird, guys. Okay. Hey, Vanetta, what's up, my love? Yeah, that guy was a sicko. He sure was. De La Paz. Yes. I would love to know why they sealed the government's response. That ought to get the conspiracy theories. Oh, yeah. You know what? I forgot about that, guys. Let's go into that. Let's get into that. Thank you for reminding me, Take. Thank you, baby. Okay. It's here. Okay, now let me see if I can better thing. Oh, before I do that. Okay. All right, guys. Let me, you know what? I'm going to move myself out. I'm going to put it on solo. Okay. All right. So, guys, wait, stop sharing. Wait. No. Okay, yeah. Okay. Now, I'm going to go off the screen so I'm not watching the chat again. Okay, guys? Okay. Now, right here, where it says 411, Ms. Geddes yesterday put in a response in opposition, read 276 supplemental motion for new trial. Attachments. Exhibit A. Number one exhibit A. So, what happened is that they added an attachment. Exhibit 1. Exhibit A. Attachments number 1, exhibit A. That's all it is. They put an attachment because in 276 up here, right? Look, Bonjean, supplemental motion for new trial by Robert Sylvester Kelly, attachments number 1, memorandum in support, right? Right. So, this is her attachment, exhibit A to exhibit 1. That's it. That's all it was. They sealed it. Now, let's go up from the top, from where it all started. Okay, because people were confusing out here. Where was it? Okay. Now, it all started with 269, right here. 269, which is February 17, 2022, document number 269, which was the motion for acquittal by Robert Sylvester Kelly. They put an attachment, which was memorandum in support. So she put the motion, the little letter, and then she attached the motion. Because remember, it was like 3 pages, and then the other page was like 64 pages or whatever the hell it was, right? Or 22 pages, whatever that one was, right? That same day, Bonjean put in another motion, 270, for a new trial. So she put 1 for an acquittal, 1 for a new trial. They both have attachments, which are the memorandum in support, which were those long pages, right? Okay. Now, Jennifer Bonjean, that same day, put in another document, 271. So 269, 270, and 271. She put in those 3 that day. That last one, she put in a motion for extension of time to file supplement to Rule 33 motion by Robert Sylvester Kelly. So she asked for an extension to file the actual supplement to the rule for the motion 33. Okay, so this here was actually a request to extend time. Okay. Then on the 18th, ordered by Judge Donnelly, she had said Order as to Robert Sylvester Kelly. The court has received the defendant's Rule 29 and Rule 33 motions, which are documents 269 and 270, right? And the defendant's request for an additional 30 days to supplement his Rule 33 motion 271, right? So the three motions are in here. This is her order and her ruling for these three motions. She said the defendant's submissions do not comply with my individual practices and rules in two respects. First, the defendant's Rule 29 motion is 56 pages long and no application for extra pages were made. So in other words, she didn't ask for permission to put extra pages. We all know it's supposed to be only 25. She went over that. So she needs to correct that, right? Then she says, under my individual practices of Rule 4C, unless prior permission has been granted, memorandum of law in support or in opposition to motions are limited to 25 pages and they're double spaced. And you must request a file memoranda exceeding the pages limit. The pages limits must be made in writing 5 days prior to the due date. So she had to write a letter 5 days before the due date of the filing to request to have those pages entered. Okay? So she said the 269 motion is therefore denied without prejudice to refile in accordance with my individual practices and rules. So the defendant must refile the motion no later than February 8th, 2022. Right? Then it says the government must respond, and their response is due by the 20th. Okay, so February 28th to March 20th, she gave her 3 weeks. More or less, 3 weeks. Okay? That's about 21 days she gave her. Now, the defendant must reply to the motion no later than February, and the government responds by March 20th. Okay, and that's for the 269 motion. And the defendant's reply, if any, is due by April 4th. So now, the government had until the 20th to respond. And then once they respond in March 20th, the defendant had a chance to reply. If there is any reply, they don't have to reply. It's if they disagree with something or if they agree with something. If they want to reply, they did not have to reply. Again, they do not have to reply. And that's the defendant. So the defendant had a chance if he wanted to reply to anything, if he has any objections or anything else to say, is due by April 4th. Second, the defendant's 271 request for 30 days to supplement his Rule 33 motion, which I construe as an extension request, must state, among other things, the government's position on the request. So the defendant's submission does not provide this information. I therefore deny the motion without prejudice to refile. Any resubmission must state whether the adversary consents and, if not, the reasons given by the adversary for refusing to consent. Then it says, see individual practices of Rule 2, F ordered by Judge Donnelly, and she made that order on the 18th. So now, Ms. Bonjean puts in her motion, 272, which was the letter motion, for leave to file excess pages memorandum of law. Right? She entered that on the 19th. Okay? The 18th is when she requested that she change that up and asked for permission to add extra pages. She did that on the 19th. Okay? Now remember, it says the defendant must refile motion no later than the 28th of February. She filed it on the 19th of February. Then, on February 21st, now as you can see, the defendant's rule motion 269. Okay, wait. What was it? Okay. Now here it states that the 269 motion is therefore denied, right? The defendant must refile motion no later than February 28th. Now, the government's response is due by March 20th, right? The government didn't respond to the motion until the okay. They didn't respond until March 21st, 2022. Okay? And that was to respond to 270 and 270. I don't think she wrote that right. 273 is 273? Oh, okay. Yeah, 273. But that was after. Okay, wait. I'm confused here. Hold on. Okay, to 269. So, all right. They responded to okay, wait. What was it again? The 21st? Okay, right here. The 21st is when they entered everything. Okay, so now, let me see again. Okay, the defendant must file the 28th. Government's response is due by March 20th. And the defendant's reply, if any, is due by April 4th. Second, the defendant's, okay. Okay, so then they went to 272. Jennifer Bonjean had put in the letter motion to leave the excess of files of the paperwork. Then the judge granted it and said that's fine. She could leave those excess pages on the 21st. Then The 27th of February, Ms. Bonjean had put in a motion for acquittal, attachment number 1. And then the 27th, she also entered the motion for extension of time for the Rule 33, which is the new trial. Then March 1st, order granting 274 motion for extension of time to file. The defendant supplement Rule 33, if any, is due by March 21st. So now it changed from that was, wait, what does it say? On a granting motion to extend the time. Okay, so she gave her one more day, right? Because it was the 20th. She gave her an extra day. And she said no further extension will be granted, right? And she entered that on March 1st. Okay. So now the government had till March 20th, right? Okay. Then all of a sudden, March 10th comes and Judge Donnelly puts in another order. And it was to Robert Sylvester Kelly. The court has received the defendant's 273 motion, which was the shorter version of the motion for acquittal, 273, right? So she's letting everybody know that it was received and that the government is to respond now by March 21st, 2022. They had till the 20th. They also got an extra day, right? And the defendant's reply, if any, was due by April 4th. Here it is, March 17th, 275. Motion for leave to file excessive pages. Defendant's Rule Procedure 29 and 33. The government entered their motion by the 17th for the leaving of excessive of file pages, right? March 17th, Judge Donnelly ordered granting 275 motion to leave for those excessive pages, right? March 21st, rule document number 276, supplemental motion for new trial, Robert Sylvester Kelly, by Bonjean. She put in the supplemental motion. She had till the 21st. She put it in. Then, March 21st, 2022, 277. Wow, look at here. Response in opposition, re 270, first motion of new trial, and response in opposition of 273, motion for acquittal. What do you know? They all put it in at the same time. Everybody was right on time. Nobody was late at all. At all. Nobody was late. They all did it by the 21st. She gave them an extra day. Right? Right. Now everything has to happen by April 4th now. Remember, April 4th is the deadline, right, for the government's response. The government and defense. Hold on, let me double check. Right. The government and the defendant, it says here, for the motion for acquittal for 273, the government had to respond by the 21st. They did. And the defendant's reply, if any, is due by the 4th. Okay? Okay. So now the 29th approaches. Number 279, document number 279. Bonjean entered this. She put in the first motion to continue sentencing. Right? Now, the day after, on March 30th, the judge comes in and says, the court has received defendant's 279 motion to continue sentencing. The government's response is due by April 4th. Right? And the defendant's reply, if any, is due by April 7th. That's for the 279 motion, which is for continuing sentencing. Correct? Correct. 4322. 280. Motion for leave to file excessive pages in reply to government's response was put in by Bonjean. She had until the 7th of April. Right? Here it is. She'll respond. April 4th. They had also till April 4th. The government had till April 4th. The defendant by April 7th. Now, April 3rd, the motion to leave the excessive pages by the government by Bonjean. Then, on April 4th, Judge Donnelly came back and said, order granting the 280 motion to leave the excessive pages. Now, the 4th. Well, what do you know? They had till the 4th, right? Right. So in response, opposition, read 279 motion continuancing. They responded to that. The 4th, 282, reply to response. 273 motion for acquittal. 273 motion for acquittal. She had till the 4th as well. So they all replied on the 4th. Then Jennifer Bonjean also put another motion for 270. She replied to that one as well. Then comes the 5th. Judge Donnelly comes in and she says, well, order granting in part and denying in part 279. Right? To continue the motion. So she gave her that. That's when she said, okay, we're going to change it. We're going to change his his sentencing date. We will grant you that in part. I'm going to deny it and I'm going to partly grant it. She granted it by giving her till the 16th for the sentencing hearing. Now, the parties are reminded that any objections to the pre-sentence report are due by April 19, 2022. Okay? Just remember that date, guys. April 19, 2022. So now, on the 5th, Bonjean put in a letter motion for reconsideration, order on the motion to continue, right? Then April 5th, Judge Donnelly came back with an order. And she said the government is directed to respond to defendant's 285 motion for reconsideration by April 7th. Here it is. April 7th comes. What do you know? The government responded to 285 motion for reconsideration. Right? They responded on time. Right? Okay. Then on the 9th of April, Ms. Bonjean put in another letter motion to reconsider the order of motion to continue sentencing. Then the 11th, which was yesterday, the government replied to her 276 supplement motion for new trial. Attachments. Exhibit 1A. That's it. She was just responding to the attachment. That's it. And they have until the 19th, which is what they're doing right now, fighting back and forth about the pre-sentence report and the 279 motion to continue his sentencing. And now we're waiting for Judge Donnelly to reply to everything. So, and she has like 60 days or something like that to reply. So I don't see anything anywhere that says that the government fucked up. Sorry, wrong information. Please stop misleading the people. I beg of y'all. Please stop misleading people. Please. It's so annoying. It's annoying. Okay, where is... When I have put something up here, guys, I don't know where it is. Where did I put it? Oh, is this it here? No. Was this it here? Okay. All right. Let me close out some other stuff and then I'm gonna end this live, guys. Let me close out some windows here. That's probably why I was having issues before too.
Baby, look at me.
Okay.
That's what I want.
All right. Now, a motion or order to show cause. Both a motion and an order to show cause are used to ask the court to do something in a case. But a motion has strict rules about the number of days it can be served before the court date. Many people find it easier to make an order to show cause because the court sets the court date and tells you how to deliver the papers to the other side. An order to show cause is good to use in an emergency situation. It can often get you into court faster than a motion. And it can ask the court for immediate help until the case is back in court, such as stopping a sale of a home or the taking of money out of your bank account. This is called a stay or a temporary restraining order. Some people may be afraid that the judge won't sign the order to show cause, but still want a chance to see the judge and argue their side. So when you're making a motion papers consist of a top page called a notice of motion, followed by an affidavit in support. Now, copies of any documents that the moving side thinks would help the judge make a decision. The party making the motion is called the movant. Now, the notice of motion telling the other side the date the motion will be heard by the court. Now, this is sometimes called the return date, or the date the motion is returnable. This date is chosen by the movant. Choosing the date is the hardest part of making the motion. The court clerk can help you choose the date. It matters if the papers will be delivered to the other side in person or by mail. This date must give the other side at least 8 days of notice. But if the motion will be delivered by mail, the date must give the other side at least 13 days of notice. If the movant wants copies of the other side's opposition's papers and any notice of cross motions, at least 7 days before the hearing date to be available to review them and reply to them. The movant chooses a date that gives the other side at least 16 days of notice. If the motion will be delivered by mail, the hearing date should be at least 21 days after the motion papers are mailed. So the date must be a day of the week that the court is available for motions. Beware, not every court in New York State hears motions every day of the week. The notice of motion must also list the full address of the courthouse, the courtroom number and time. The court locator box can help you with that. Okay. What was the other one here? Okay, so affidavits in the support, both a motion and an order to show cause must have an affidavit attached. Affidavit in support is a sworn statement signed in front of a notary public that tells the court why a motion or order to show cause should be granted. The movant can file as many affidavits from as many people that he or she thinks will help the judge decide to do what he or she wants. The affidavit should say what is being asked for and why, the facts about the case, whether or not the movant has ever asked the court for this before, and if so, what happened and why the movant is asking again. So attach copies of any important papers that you talk about in your affidavit to the motion or the order to show cause. These are all called exhibits. The exhibits should help explain and support your motion. Mark each exhibit at the bottom of the page as Exhibit A, Exhibit B, and so on. Exhibits are not returned to you. Make copies of the papers so that there is a set for every party. The copies must be delivered to the other side. Okay, the court keeps the original papers and proof that the papers were delivered to the other side. Okay. Opposition papers. The other side can tell the movant and the court why he or she thinks that the movant should not get what he or she wants. This is done in written papers called an affidavit in opposition. The movants can limit the amount of time the other side has to file opposition papers. The notice of motion will say when. So if the other side does not submit opposition papers and or doesn't come to court to argue against the court granting the motion or the order to show cause, the judge may decide to grant it. So if opposition papers are filed, the judge will read them before making a decision. Any important papers talked about in the affidavit should be attached to the affidavit in opposition. The papers should be copied and delivered to the other side and the court. The court gets the original opposition papers with your notarized signature at the end of the affidavit and proof that the papers were delivered to the other side. Okay? And when there's replies, the reply papers say anything that answers what was said in the opposition papers. A reply affidavit must be delivered to the other side, and the court gets the original and proof that the papers were delivered. There is no time to serve the reply papers. They can be brought to the courtroom on the court date. If the movement didn't have time to make reply papers and thinks it is important, he or she can ask the judge to postpone the case to another day for time to reply. The judge may or may not allow this. And then this is cross motions. We're not even going to that one because that's not. Okay. Now, decisions. If the motion can't be settled, or the order to show cause, it can't be settled, the judge will make a decision. Sometimes the judge makes a decision right away. If not, the judge has 60 days by law to decide the motion. Some judges will mail you a copy of the decision if you give them a self-addressed stamp. Bring one to court. You can find decisions for some courts by checking calendar information at the e-courts. If not, call the court clerk or go to the courthouse to get a copy of the decision. Okay? Okay. Okay, so if the party is unhappy with the judge's decision and thinks that the judge made a legal or factual mistake, the party can appeal. There are time limits on filing an appeal if the decision with notice of entry has been served and filed. So just giving you that, guys. Okay. And what happens after a person's been convicted of a crime, right? So if you're convicted of a crime, your case is not over. The next step for the court is to determine your sentence. How you will be sentenced depends upon a number of factors involved in your case. Additionally, you have a right to appeal your conviction, and you should not hesitate to speak to an experienced sentencing attorney about exercising that right if you believe errors were made during the criminal justice process. So the sentencing process is one of the most important aspects of the criminal justice system. During sentencing, the court will decide your potential jail or prison sentence and impose penalties that could impact you for the rest of your life. That is why it is important to speak to an experienced sentencing and appeal attorney right away if you have been convicted of a crime. Now, the sentencing process is if you were convicted by a jury at trial court, your case will transition to the sentencing phase. The sentencing process is one of the most complicated areas of criminal law. In some cases, your sentence could be straightforward. However, in most cases, there are a lot of factors that judges must consider when determining your sentence. However, the sentencing process will work in your case is largely dependent on the type of crime you are convicted of. So, for infraction cases, the sentence is determined immediately. In misdemeanor cases, the sentence is determined no less than 6 hours and no more than 5 days after the verdict, unless you waive this right or the court extends it. So the felony sentencing process is much more complex and can take several weeks. Misdemeanor crimes typically carry 6 months or up to 364 days in a county jail. Felony offenses generally allow judges to choose between 3 sentencing options for imprisonment. During the sentencing process, it will be up to a judge to consider all the factors involved in your case and make a decision as to which punishment fits the crime. Now, you do need an attorney during the sentencing process. Okay? Now, during the sentencing process, the probation department prepares a report. Okay? As we know, the pre-sentencing report, right? This is what's going on now with Robert Sylvester Kelly. We're waiting on the pre-sentencing report and all of that, right? Now, the probation department is the one that prepares the report. And they recommend to the court what the appropriate sentence should be. So both your criminal sentencing attorney and the prosecution are legally entitled to receive the probation department's report several days prior to the sentencing hearing. So they will get that report before he gets sentenced. Okay? Now, then afterwards, there might be what they called a restitution hearing. Okay? Now, if you're convicted, you will more than likely be required to pay restitution to the victim as part of your sentence. However, every criminal defendant has the right to a restitution hearing. So a restitution hearing grants you an opportunity to challenge the restitution itself or the items it covers. So the court has the power to reduce or entirely eliminate the restitution in its sole and absolute discretion. So the court bases its determination on the amount of loss claimed by the victim or victims, or any other showing to the court. Now, the victims or the victims' representatives present evidence to show that losses occurred and such losses were caused by your criminal act. So at a restitution hearing, the evidentiary standard is lower than that of criminal trials. So rather than having to prove you are guilty beyond a reasonable doubt, restitution must be proved by a preponderance of evidence. So in a restitution hearing, a preponderance of evidence means that there is a greater than 50% chance, based on all the reasonable evidence, that you caused damage that requires restitution. So, Mr. Kelly, as we all know, in his case, there was a preponderance of evidence. Am I correct? Right. So, there is a 50% chance that, based on all the reasonable evidence, that he caused the damages to the girls, and that requires restitution. Now, if the victim makes a prima facie showing of economic losses, the burden shifts to your criminal sentencing attorney to disprove the claimed losses. An experienced criminal sentencing attorney may be able to disprove the losses by showing that the restitution recommendation in the probation report or in the victim's estimates is accurate. Is inaccurate. Sorry. All right. Now, the last thing, and then I'm going to end this. Appealing your sentence. It is also important to note that you may be able to appeal your sentence if you believe the penalties handed down by the judge in your sentencing hearing were unfair or unjust. You could have valid grounds to appeal your sentence if the judge made a mistake in applying the law to your case. For instance, if a judge applied the wrong sentencing factors when determining your punishment, you may be able to win your appeal. A judge may impose a sentence that is not authorized by law or a sentence that is a significant departure from what a normal or similar sentence should be. This could result in your case being sent back to the sentencing court. So winning an appeal of your sentence does not mean that you will no longer have to serve your sentence. You will have to go through sentencing again. You could wind up facing the same sentence, a lighter sentence, or a harsher sentence. So, like appealing a criminal conviction, you must act quickly to appeal your sentence. You have 60 days to file an appeal in a felony case and 30 days to file an appeal for a misdemeanor case. Due to the restrictive time frame and the potentially significant impact of a successful appeal, it is crucial that you consult with an experienced criminal appeals attorney as soon as possible. So R. Kelly, he has 60 days to file an appeal to appeal his sentence after he's sentenced. So he has to wait 60 days and then file an appeal. Oh, up to 60 days. You have 60 days to file the appeal. So he has up to 60 days to file for the appeal for his sentencing. Wow. Meaning you still do time, but trying to get less time. Exactly. That's correct. All while going off on Twitter, she's a busy girl. Sounds like she knows his best bet is to share his trauma with the court so they go lighter on him. I agree with that, Miss Mo. I agree. I love you too, Tears. I think that's why Miss Esquire was like, girl, why you don't want to be a lawyer? You need to be a lawyer. Yes, you do. You do. Don't go for paralegal. Girl, you could be a lawyer and sit in the background. That's just too many years of schooling. I'm already 50, almost 50, guys. I'm almost 50. Let me just deal with the 2 years of school. I'm good with that. I got like a year to do my GED, 2 years to go to paralegal school. That's good. 3 years. By that time, I'll be almost 50. And then I'll work my ass off being a paralegal till I retire. Until I decide to stop working, That's what my goal is. So, yeah. I love you, Tears. Hey, Armin True. Hello, how are you? Welcome. Please don't forget to hit that like button and subscribe if you are not. Daddy's girl, my girl, Shaw baby. Hey, just the tea, please. What's up, mama? I'm glad you are breaking this down because I don't think I would be able to get my head around this. Girl, I read it and I was just so confused by reading it. And I'm like, I know memoranda has to do with reading your rights, right? Okay. And then I'm like, okay, allocate. What is that? And what? Uh, okay, no. Let me read this and break this down because I'm confused. So I was wondering if maybe some of y'all might be confused. Like if I was confused, I know some of y'all might be confused. You know, we're not lawyers. We don't know the law like that. Hey, Tequila. Mitigation also involves remorse and showing an understanding of harm to the victims. Yes, it did state that. We did read that. Yes, it did state that he has to have some type of statement for the victims. Yes, he does. Yes. That admission of guilt could hurt him in Chicago. Right. See, this is what Bonjean is fighting because if he does this, it could be used against him, according to memoranda. Okay? According to the Fifth Amendment. So it makes sense that Bonjean would want to wait. I get it. I get it now. I get it. I understand now. I get it. I don't need help, baby. I love you, mamita. Thank you, Nuni. My baby Nuni. Okay, so we're saying hi again. Les Smith. Hey, Les Smith one. You are doing amazingly. Keep going. The silent ones need your voice. Thank you, honey. Thank you. Mertie says, I doubt if R. Kelly is going to say much to the mitigator. This is just a trick to buy more time. It is. Honestly, she's doing what she has to. She's doing her fucking job, bro. She's doing her job, straight up. She's doing her job. You know, I have to admit that she's doing more of her job in less time being with him than Greenberg and his old team. I have to admit, she's doing very well for R. Kelly. You go, R. Kelly. You got a good lawyer, but the prosecutors are still going to whoop your ass. You ain't winning. That's it. That's all. All the other times, he just paid them off. Absolutely. And didn't talk at all. Absolutely. James Harris, who you calling old woman? Yeah, really, James. James, I have a problem. James, I have a problem, James. Uh-oh. Where's blocking ass Tasha when you need her? She be in and out. She be in and out, Robin. Okay. Hey, anybody I missed earlier? I had to step off a few. Okay. Is that the sealed document that's causing all the late night YouTube speculation? Yes, Kayla, mommy. Yes, mommy. Yes, baby. Yes. The misleading of the information because people are half asleep at like 2 a.m. and shit. Their brains aren't all together. So that's why I had to do it now at this time because my brain's working. Sparkety spark spark. Okay. So, yeah. You're absolutely right, Kayla. Yes, mamita. Holy long paperwork, Batman. Yes. Well, the actual letter was only 2 or 3 pages. But all the other breakdown of everything else that I went through was longer. RSK's letter to the judge. I didn't do this stuff. This was all in my way, way past. I gave y'all 30 years of my life. Oh, shit. Miss me, Miss Mo, that's a good one. And I'm pretty sure he's going to repeat exactly what you said. Hey, Destiny. What's up, mamita? Glad to see you here, baby. I see you always on Facebook. It's a good thing to see you on YouTube. Welcome, welcome, mommy. Welcome. Okay, let's see what else. Yes, can you please hit the like button for me, y'all? Thank you. Hey, GA girl, what's up, mamita? How are you, honey? Okay, let's see. All right, everybody saying hi to everyone. Okay. Yes, mommy, Friday or Saturday, flawless. I'm going to get in touch with you ladies who own businesses. So, Queen Newton, this 504 girl, flawless, um, oof, God. I have a couple of you guys. I can't think of all of y'all. Jesus. My ladies, y'all know who you are. Reach out to me on Messenger on Facebook or Instagram. All right. And remind me that you guys have your businesses so that we can make a live on Friday or Saturday. All right. And I want to promote everyone's business. So I would like for all you ladies to join me on the panel. All right. Join me on the panel and talk about your businesses. Okay. I want you guys to promote your stuff. All right. You guys support me. I want to support you right back. Okay. Best way that I can. You know, advertisement and networking is one of the biggest things, you know? So I would love to help you guys network as best as I can. Okay, let's see what else. Nika Jackson said, just like your King Larry McGee, he have to pay too. Oh, yes, he does. He has to pay restitution. Sure the fuck he does. And let me tell you, he's regretting everything he did. Believe you me, my brother is learning his lesson right now. He sure is. And he's sitting there like a man should sit there and take it. He's not trying to write letters to get out of jail and get bail and all these things and pray. And he's just there doing his time. He knows that what he did was wrong. He's doing his time. And he will have to pay restitution. He was told that. And it's going to take him a long time to pay that restitution back. And he knows that. So your comment is irrelevant and it has nothing to do with R. Kelly. Okay? Okay, Nika. Thank you. Hey, Jennifer. What's up, mama? Okay. I can do it. You know I can do it, but I'm not going to do the lawyer thing. I'm telling you guys, I'm not doing the lawyer thing. That's just too much for me right now. It's just way too much. Maybe if I would have done that in my 20s, yeah, definitely. If I would have really, because I actually wanted to be a teacher. I wanted to be a dance instructor. I wanted to own my own bar. I wanted to own a restaurant. I wanted to get into culinary arts. Yeah, I had a lot of dreams and aspirations for myself, but he has no remorse because he says he's innocent. Exactly. He's never going to admit his guilt. I believe that. Memoranda and Miranda are different. Right. Memoranda is a memo, okay, a notice. And Miranda is your right to remain silent and to have a lawyer present. Okay. You was waiting for me, Shorty. I love you, Shorty. He's still not getting out. Right. Larry's going to be sitting on YouTube, chilling with us. And R. Kelly's still going to be in jail. So all that stuff these people coming in here and doing is irrelevant. Irrelevant. It's so weird to me to see Rob's fans so obsessed with Larry. It is. It's the strangest fucking thing ever. It's the weirdest thing ever. Friday is best or early Saturday? Okay, mama. Friday evening? Noni, Friday evening? And not denying it like y'all master Kelly. Exactly, he's not denying it. Our brother's true man at heart. He admitted his wrong. He did what he did. He had to, and he's holding it. That's it. Y'all just mad because he's holding it down and R. Kelly's crying like a little bitch. That's what that is. Whatever. Yes, take R. Kelly. It really is. Larry's a real man. I'm sorry. Most of y'all are just males and poor excuses for them as well. Exactly. It's not too late. I love you guys. Y'all master RSK, Miss Honey. That was funny. Only if Robert Kelly. Hey, Karen Johnson. What's up, baby? Only if Robert Kelly would omit his crimes. Diva, stop it. It's not too late. It's crazy to me to not hold a grown ass mofo. They don't know accountable, not for anything. Impossible. Exactly. Okay, Friday. You know what? So I'm going to do it Friday, y'all. I got some things to do Friday in the daytime. So that's why, if anything, I'll do it Friday in the evening or Saturday in the afternoon. All right. It's the last Good Friday, right? Okay. All right, you guys. So that was the end of this live. I'm glad you guys stuck around with me and we got to learn a little bit about more in depth of what the letter meant, and also cleared up the confusion with the dates of the orders that the motions were put in. So just to let you know, nobody was late. Nobody was being sneaky. Nobody was doing any of that. Okay? Okay. So, guys, y'all already know what to do, right? I'm Catholic too, my love. I'm Catholic too, but I don't follow my religion like that because hypocrites, pedophiles, I'm just not feeling the church anymore. So, guys, do me a favor. If you would like to donate to the channel, y'all already know $ Diva Divine Light is my Cash App. If you guys would like to donate, please do. You can also donate to my PayPal at paypal.me/Diva Divine Light. And you can also Zelle me, guys, 347-664-9253. The information is scrolling on the bottom of your screen. If you guys would like to hit me off with a super chat, you can click the little $ that's on the right side in the chat. And you guys can click a super chat. And I am out. Like, this was a lot, guys. We will be back because I have a lot of other things in store for you guys. All right. Just make sure that y'all don't forget to please like. Hit that like button. Okay. And don't forget, for those who are not subscribed to my channel and you're new, please subscribe to my channel. Okay. Hit the notification, the little bell on the side, put it on all so you can get all my uploads. All right. And for those who are watching the replay, please make sure you leave a comment below in the video, in the comment section below. Thank you. And if you are not a part of my members only, please join. It's only $1.99 a month. And you get little perks. You get to put emojis in the chat, personal emojis. And I also do exclusive content in my members only, which we got some pretty good stuff in there, guys. So for those who are members, and if you have not seen my recent video in the members only, please go over and do so. Go to my channel, look, and it shall say members only videos, and check it out, guys, because I want to know what you guys think. Leave me comments in that video as well. And if you are not subscribed, please subscribe to my membership. It's only $1.99 a month, y'all. All right. All right, guys. I love you guys. Diva Divine Light is out. Peace.